It's 11 o'clock, but let's wait for maybe a minute or two before we start. Hello, everyone. We're just waiting for a few more attendees. We'll just wait a minute or two before we start. Bor, shall we start? Or you want to give it another minute?
I think we can start.
Okay. All right. Hello, everyone. Good morning, good afternoon, or good evening, wherever you are. My name is Gretchen Aquino, and I will be your moderator for today's webinar. This webinar is on the presentation of the draft report on e-commerce law in the Kyrgyz Republic. Please note that this webinar is being recorded, and such recording may be made available to the Law and Policy Reform website of the Office of the General Counsel or such other ADB platforms as may be available. We're happy to inform everyone that we have simultaneous interpretations available in today's webinar in the English and Russian languages. Feel free to switch to your preferred language found on the lower right portion of the Zoom app. The program will start with the presentation of the draft report by the ADB e-commerce law consultants, followed by inputs from our esteemed guest panelists. And later we will have the Q&A for anyone who may wish to provide their inputs, questions, or suggestions. We will discuss the Q&A sent in through the registration in the chat provided in Zoom, or you may also raise your hand at the Q&A portion later on. We would be happy to entertain them. To start off and welcome everyone and provide background on this draft report, I would like to call on my co-team lead on the technical assistance on enabling a conducive environment for the digital economy, Mr. Borjan Konisbayev. Borjan, I pass on the floor to you. Over.
Thank you, Gretchen. Distinguished guests, colleagues, ladies and gentlemen, thank you for being with us today. The internet has dramatically changed the means and methods of human interaction. Because of the internet, we witness an exponential growth of e-commerce and rapid development of digital economy. In 2003, Amazon, the biggest e-commerce store for books, made its first profit. In 2021, Amazon sales nearly $500 billion US. Today, over 2 billion people shop digitally, which is 900 million more than in 2020. That's a 72% increase in just 2 years. Global online sales are estimated at nearly 5 trillion. Digital technologies are penetrating and already experiencing high growth, rapid innovation, and broad application to other economic sectors. We are witnessing life-changing application in development of artificial intelligence, big data, machine learning, blockchains, and Internet of Things. Up to 70% of internet traffic comes from mobile devices. And no surprise, since about 3.5 billion smartphone users worldwide, and those are economically active. By 2040, about 95% of all shopping will shift online. This expansion of digital landscape provides opportunity for economic growth and human progress. However, the huge potential of digital economy may yet be stifled by overregulation, legal ambiguities, diverging standards and practices. Transparent, predictable, enforceable legal and regulatory framework is a key prerequisite to a strong enabling environment. ADBTA aims to analyze legal and regulatory barriers for effective and efficient development of electronic transactions. We aim to reduce the digital divides regionally and accelerate international harmonization. Working together with the government and industry leaders in Kyrgyzstan, in close cooperation with our peers at CAREC Institute, ITC, and UNCITRAL, we play an important role of shaping the path for legal and regulatory enhancements for internet growth. We count on Kyrgyz government and industry leaders for your support in this endeavor. Ladies and gentlemen, allow me to introduce our esteemed speaker today, John Gregory and Iskander Artigbayev. John is a commercial and technology lawyer in Ontario, Canada. He developed legislation for the provincial government for over 30 years. He was a leading Canadian expert on laws relating to electronic communications, as well as serving on the Canadian delegation to the UNCITRAL working group on electronic commerce for 16 years. Since his retirement from the government in 2016, he has been active as a consultant in this field, notably for Asian clients like UNESCO, the CAREC Institute, and ADB. Iskander Artigbayev is an expert in the field of legislation of the Kyrgyz Republic. He took part in various projects of international organizations, including ADB, Organization for Security and Cooperation in Europe, the UN Economic Commission for Europe, and he developed recommendations for the government of Kyrgyz Republic on the improvement and harmonization of legislation in order to identify barriers that hinder doing business in Kyrgyzstan. Together, they developed a draft report on e-commerce laws in Kyrgyz Republic. And today, they will present their initial assessment of the legal framework governing electronic transaction in Kyrgyzstan and their recommendations for further enhancement. Without further ado, I give this virtual floor to John and Iskander. John, over to you. Thank you.
Thank you. I have a slide deck which now appears before you. I'll go to the first substantive slide. Next slide, please. To give you an overview of what I'll be talking about, which is essentially electronic transactions in general and the Kyrgyz law on electronic transactions of platforms and signatures. What have they got in place now? And Iskander will follow that up with some discussion of, well, what happens in practice within this legal framework that they've got. After that, I will take over again and talk about some of the considerations that you have to have if you're going to do law reform in this area at all, and in particular, what the international setting looks like for this kind of activity, since e-commerce takes you across borders very quickly once you start doing it. Then we will talk more specifically about particular areas of law reform and compare our recommendations to an action plan that the government of the Kyrgyz Republic published earlier this year. I will point out to you when we're looking at the overview, because you won't see it again, that there are two appendices on this. One is a broader discussion of the nature of electronic communications. Why does it matter if you take the paper away? And some of the initiatives that have been done in the world to remove those barriers. And the second is a more in-depth look at the law of electronic signatures in the Kyrgyz Republic. These are in the slide deck. For those of you who will take the slide deck away, you can look at it later. The draft report that has been mentioned has a good deal more discussion on both these topics. So they're in here for completeness, but I do not propose to talk about them. Next slide, please. So when we're talking electronic transactions, we're talking commerce, which is transactions with a view to a profit. Usually other transactions are possible. The basic law of transactions in the Kyrgyz Republic, as in most countries in the world, frankly, is in the civil code. The civil code talks about what the elements of a transaction are. The civil code's language is what we call media neutral. That is, it applies the same whether people are using paper documents or sending telexes or faxes, or even when they're speaking to each other orally. And likewise, it will apply to electronic communications. And the essence of a transaction in all of those cases, for all of those media, is have to know who the parties are, who is transacting with whom, what are they transacting about, what's the subject matter, whether it's a sale of goods or an offer of services or whatever it happens to be, and what's the price. All of those are needed in order to have something that's enforceable at law. And if it's not enforceable at law, it really doesn't matter what the law is, I suppose. So let's look at e-commerce a little more closely with that background, but keep the background in mind. Next slide, please. So there is a statute, a new statute in the Kyrgyz Republic, the law about electronic commerce, which was passed last December and just came into force a couple of months ago. It defines an electronic transaction as a civil legal transaction. In other words, one that's covered by the civil code with the elements I just mentioned in the civil code. A civil legal transaction between participants in electronic commerce through information and communications technology. So the only difference between any other transaction and an electronic transaction is the use of the right kind of technology. There are a number of principles about electronic transactions that are set out in the statute. There are two that I think are most important for the discussion right now. One of them is that electronic transactions are legally effective. So it basically says, all right, you don't need paper. It's a basic comfort for someone thinking, can I do this electronically? The answer in the statute is yes, which is good news for everybody at this point. The next element that I pulled out of several principles is that the electronic documents have this legal effect regardless of the method of their conclusion, that is how you negotiate them one way or the other, online, offline, whatever, and regardless of the method that you use to sign them. Now, there are several methods of signing that are in the law on e-commerce and in the electronic signature law, which is a separate statute in the Kyrgyz Republic. But it doesn't matter which you use. For most purposes, for private transactions, any of them will be legally valid. So it's very useful to know. The documents that you're using may be machine readable or human readable, doesn't matter, as long as something is being processed that is detectable later for legal purposes. There are certain exceptions for that we won't talk about here because we're at a higher level this evening. Next slide, please. This evening, this morning, wherever you are. There's an interesting set of provisions in the law about electronic commerce on what they call electronic trading platforms. Trading platforms tend to be the way most people do electronic commerce, certainly the consumers. You go to Alibaba, you go to Amazon, you go to Tencent, you do whatever your local or regional or global platforms. That's where you go to find your goods or services. That's how the merchants, the providers of goods and services provide them to you. So it's important that the obligations and the rights of the operators of that platforms are taken into account in the law. This is fairly recent in legislative history and e-commerce in the world, that we're looking more specifically at the platforms and saying, who are these people and what are they doing? Who are they to me, the consumer? Who are they to me, the business person? So the obligations are to make the goods and services available. This is really basic, but you don't want to not say it just because it's basic. You keep the seller's interest and the platform operators' rights and duties separate, so you know who's doing what for whom, when. You have a policy for the users of the platform ensuring the quality of goods and services. In other words, there's consumer protection content in this statute, which is important. We'll come back to that later. Ability to search the platform. You want to make it convenient, and to assist the participants in protecting their rights and interests. This is the platform's duty. So it's very important, and I think it'll have a lot of impact as we go forward because of the importance of the platforms. Next slide, please. I've mentioned electronic signatures already. The main reason you care about the signature is because you want to know who did this. You want to know who you're dealing with. Either the seller or the buyer wants to know who they're dealing with. And what you use to identify people when you're dealing in person, you often don't have when you're dealing electronically, like a face or handwriting. So how do you do this? Electronic signature is a big part of that. There are a number of ways of doing electronic signature, and the Kyrgyz law refers to 3 of them in the law of electronic signatures. That's discussed later, and I won't go into the detail at this point, but just to say there are a lot of ways. But the transaction parties, particularly private parties, have a lot of flexibility in deciding what they are comfortable with in signatures and in authentication. And if I've been dealing with someone for a long time, I may be very comfortable with a very casual signature and very casual authentication, because all the indicia of the transaction show that I can trust it. If it's a stranger and it's a high value, I may want a very precise and trustworthy signature. And speaking of trust, the law has provisions about trust services, particularly certification centers in the Kyrgyz Republic that will identify who is the party, the legal personality behind certain kinds of electronic signature, and will issue certificates saying this signature was created by this person for this purpose at this time. Very useful when you are dealing with relative strangers. So there's a good deal of stuff in the law on that subject. Next slide, please. Here we're going to talk about what happens in practice despite this fairly flexible and fairly up-to-date law. And I'm going to let Iskander, who's actually in the Kyrgyz Republic, speak to what happens where he is. Iskander.
Спасибо, Джон. Хотелось бы, в свою очередь, также поблагодарить всех участников этой конференции.
Thank you, John, and thank you to all of the participants of this webinar, and to ADB, Ministry of Economy and Commerce, for your efforts undertaken for the projects ongoing in our country. I would like to highlight the professionalism of Mr. John. We have worked last six months, and our work, I hope, will impact positively the economy of the Kyrgyzstan. I would like to underline that e-commerce law is at initial stage of development. Particularly the e-commerce law was adopted in December 2021 and was enacted in May 2022. The legislative framework in e-commerce was updated. Thus, according to our research, it is in line, is sufficiently in line with international standards. Nevertheless, currently, the volume of e-transactions is considered to be low. We have several reasons for this. First, the law on electronic commerce was enacted just a couple of months ago. New, and most of entrepreneurs are not familiar with it in practice, and so far they cannot use it in full. And currently, there are no sub-laws enabling implementation of this law in practice. And as the association representatives have noted, there are no clear frameworks to regulate the e-commerce. So the entrepreneurs have not clear understanding on single tax, delivery service, supply service, and there is no clear determination, no clear term for these notions in the tax code. And many people still don't trust electronic communications, and they still prefer to use paper. And electronic payments are still difficult and inefficient. So business and consumers still prefer transact in traditional ways. E-commerce Another reason for the low volume of e-commerce is the low access of population to internet, to fast internet. In remote regions of Kyrgyzstan, the access to fast internet is still low. And I would like to note that Kyrgyzstan has currently achieved significant success in development of e-communications and increasing trust by, for instance, developing and launching the electronic portal for government services, which currently offers close to 1,000 public services. The government has also developed a method of identifying citizens electronically, which can be used by citizens, by people, to authenticate them in third-party transactions. At this, I would like to emphasize that Kyrgyzstan is now a member of the revised Kyoto Convention on Customs Procedures, which provides for registration and formulation of customs procedures and for electronic processing of shipments based on likely risks associated with the shipments. The export operations will enable increase of export potential of the Kyrgyzstan. Now I'm giving word to John Gregory.
Thank you. Next slide, please. So if you accept that, the law is not in bad shape, but there are still changes needed. The question is, how do you go about this? What do you think about? And what are the areas in which you need to reform? Once you've got the electronic transaction is all right, the signature is all right, there are still areas of that require attention. The ones I'm going to talk about particularly, talk about them in more detail later, are consumer protection. What's the global standard for consumer protection for electronic commerce? Essentially timely information about the transactions. You know what you're getting into. And what happens if something goes wrong, if the goods that I get by delivery when I've ordered online are not what I asked for. Or for the merchant, suppose this person doesn't pay me, then what? But from consumer protection end, it's not the merchant's interests, it's the consumer's interest. So there are UN guidelines for online consumer protection that are the model to follow. Privacy is another area. People are worried about their personal information online, not surprisingly. There is a global standard on that, which is OECD guidelines, which have been originally done in 1980, but have been updated much more recently. And there is a draft convention or a convention to sign on that. those are the principles. We'll be talking about them a bit later. Cybercrime as well. One reason that people are hesitant to go into to do electronic commerce is they're afraid that their information will be stolen, that their money will be stolen. Essentially, there's a lot of improper stuff going on out there. How do you avoid getting into that? There is again an international model for what the law on cybercrime should be, which is the Budapest Convention. This is talked about in the report at more length. There are other topics that need to be considered if you're setting up a legal framework for e-commerce. Electronic payments that were mentioned a moment ago, public access to information. How does the public know what's going on generally in the law? Dispute resolution, civil liability for mistakes or inappropriate conduct. All of these areas need to be built in and as a framework for people doing electronic commerce with some confidence. Next slide, please. There are, I mean, the legislation regulations are only one element. So of course, you need the infrastructure, you need the computers, you need the ability to connect with people. Otherwise, the best legislation and regulation in the world is not going to help very much. Iskander mentioned this already a little bit. And the cultural views, are you used to dealing with strangers? Are you comfortable with things that you can't actually touch? It makes a difference to the success of your scheme or your framework. There's a question of how much should the state do and how much should the state prescribe every little detail of what people have to do for a good transaction, rather than trusting people to make up their own decisions. Different states and different populations will have different views as to what the right amount of state control is. But that's one of the issues. As you evolve in the law, you probably have less and less direct indirection from the state and more leave it to the parties to figure it out as they become more familiar to it. And the other thing, when the state is getting involved in regulation, you have to ask, is the state capable of doing it? Does it have the resources? Does it have the will to do this? You can say, yes, we have consumer protection laws, but is there someone to enforce it if the consumer has a problem, has a complaint? Do they have to go to court on their own resources? Or is there a government office that they can complain to, and the government office will go to the merchant and make sure that things are being done properly? Likewise with privacy, I may have a right to have my personal information protected, but if someone is not protecting it and is abusing it, what do I do? Do I have to bring a lawsuit or not? There are issues about enforcing and prosecuting cybercrime, investigating crime. Does the government have the resources? Does it want to do this? And will it do it? And that whole set of considerations affects the confidence and the success of e-commerce. Next slide, please. As I said earlier, e-commerce goes across borders very easily, certainly if you're dealing with trading platforms. You know, Amazon or Alibaba, they're not centered in the Kyrgyz Republic, you're necessarily doing international. So it's useful to set your law in the framework of the international best practices. And in our report, it sort of sets out in the various areas of law that we talk about, here is the international best practice. This is the standard. Here is what is proposed for the Kyrgyz Republic to meet that standard. It's very much the framework we're talking about. And there are a number of international texts that I mentioned here in the next slide about where do you go to look for these standards. There's the ESCAP, which is Economic and Social Commission for the Asian Pacific, UN body, has a framework agreement on the facilitation of cross-border paperless trade. Very useful. The Kyrgyz Republic is looking at going into that. There's the World Trade Organization, there's others. There are other substantive law conventions that either say directly you may use electronic communications for the purposes of this convention, or it applies it, such as the Convention on the International Sale of Goods. Next slide, please. There are also international documents that apply specifically to e-commerce and govern e-commerce rather than the substance of any transaction. The UNCITRAL text and the appendix are among them. Some standards that are mentioned here that I won't bother reading to you. Anyway, there's a lot of places for international context, and the report discusses this in some detail because it's important to set yourself into the world if you're going to have a successful program. You're not just going to have a Kyrgyz Republic little protected area without any contact with the rest of the world. Next slide, please. So in the next few slides, we look at the particular areas, the main areas of law reform that come up. Some I've mentioned, some I haven't mentioned yet, on consumer protection to start with, and some of the other areas. Consumer protection, there's already law on that subject. It's not a new topic for Kyrgyz law. There's a law of consumer protection from 1997. It was amended as recently as this year. It sets out the duties of sellers and consumers, the quality of the goods, what happens for dangerous goods, how do you attend to delivery, what are the payment provisions. There is an enforcement agency run by the state, the Coordination Council for the Protection of Consumer Rights. So there is a mechanism for it. One of the interesting provisions in it, no doubt from the more recent amendments, is sellers have to accept electronic payments if they're offered. Then the law on electronic commerce from last year that we've mentioned before has specific consumer protection provisions in it. So there's a lot of law that tells people what to do and how they're protected. Next slide, please. Earlier this year, the government published a draft action plan for electronic commerce and electronic communications, many areas of it, for the next 5 years. And it talks about a number of areas, including consumer protection. And its provisions, its recommendations for consumer protection was a register of online stores, more safety protection to make sure consumer goods are safe, and harmonize the laws with the Eurasian Economic Union, which has increasing numbers of regulations governing this. And it's the Kyrgyz Republic is required by its treaty, becoming a member of the EAU to conform with that. So our report looks at that action plan and makes recommendations. And in this case, it was pretty easy. We said, we agree with the action plan. And if you're looking at one particular recommendation, we think the harmonization with the regional rules and best practices is the really key thing. Next slide, please. So looking at privacy, again, there is a law on personal information that's been around for 15 years nearly. It is very much in line with the international best practices for privacy legislation, the kinds of things it protects, the kinds of exceptions it makes, and there again, there is a state agency for protecting it. Looking at the next slide, please, the draft action plan, sorry, slide 16, I'd like to see. The draft action plan suggests tightening the requirements to do even more protection. As big data is collected more often, the ability of e-commerce programs to take and collect consumer information, personal information, is increasing year to year. So the action plan suggests let's tighten it up and make sure we can do this with the current, quote, threats to privacy. It also suggests data localization so that personal information about Kyrgyz citizens is processed in the Kyrgyz Republic. So we looked at that in our report, and we basically agree with the action plan's domestic proposals. I think everybody in the world is going in the same direction to try to control big data and control the aggregation of little points of data that individually mean nothing, but aggregated mean a great deal. And the law should clarify that personal information should not be transferred out of the country unless there's an equivalent level of protection in the destination country. Whether data localization rules specifically, that is, you have to process it here, are a good idea is not as clear. A lot of free trade agreements these days prohibit data localization, because if businesses are carrying on business in many countries, they don't want to have a whole computer system set up in each country. There's too much duplication and too much expense. There are other ways that can solve that problem. Next slide, please. We look as well at data protection, which we define as sort of not the personal information, but protecting the confidentiality of commercial data, which is often proprietary, often sensitive, often very valuable for the people who own it. Is that sufficiently protected? There is some protection now, intellectual property, cybercrime that keeps you from stealing the contents of other people's computers. Our recommendation is it would be good to have a comprehensive statute on commercial data. So businesses need to share their data, but they also need to be able to protect it in confidence when they need to. The best practices, there is not a global standard for that legislation, but there are certainly countries in the region of the Kyrgyz Republic that have pretty good data protection laws, and we're recommending looking around and copying or at least borrowing heavily from some of those for this subject. Next slide, please. Another area that is of growing importance is access to public information. How do people know what's going on in the world? See, if people are going online, can they go online to find out what the law is and what the law is going to be? The law is changing frequently. As we talk about law reform, we talk about changing law. Can they find out? People need to be able to get that. The Kyrgyz Republic actually is quite impressive in that. It has a site, a portal for information on proposed laws. It allows people to comment on them. It allows the ministries that are proposing changes to back off, to amend it in the light of what they hear online. So it's actually a very good public forum. So our recommendation is, this is a good thing. Keep doing this. There may be public protection needed for whistleblowers, people who tell the public, hey, something is going wrong, whether it's within a business or within a government, and disclose it. What happens to those people? Can they lose their jobs? Can they be locked up, or should they be protected? It's a whole area of interest in a lot of countries, and it's one that is a natural part of this topic. Next slide, please. E-payments, I guess we're talking about cybercrime. So to go back to the cybercrime one. With cybercrime, basically, we figured the law is not bad now. The action plan doesn't say anything about it because it figures it's in pretty good shape. And our reaction is, yes, that's basically right. We put the slide in just to say, yes, we're thinking about it because it's a very important component, but it doesn't need law reform in an urgent basis now. Sorry, the next slide, please, which is on e-payments. Again, the law on e-payments is pretty good. The national bank has a lot of power to control payments and control the payment processors, the domestic banks, the credit card issuers, and so on. In practice, there's a good deal of resistance to using e-payments and using credit cards. It's difficult to use credit cards some of the time. The action plan says we'll work on expanding this in practice. Our report basically says, yes, that's right. The problem is not a legal problem for e-payments. The problem is a practical problem, so work on it. But you do need e-payments, but that's not a law reform issue so much as a practice issue, technology issue. Next slide, please. Dispute resolution is important, obviously, in any transactions between people. There may be disputes. How do you get them resolved? Mediation and arbitration are practice. They can be done online. There was just a question about online dispute resolution in a framework. It has not been part of the government agenda on online dispute resolution. The Chamber of Commerce in the Kyrgyz Republic has a new program to develop online dispute resolution. That may be promising. I know very little about it at this point, but we'll find out. But ODR, as they call it, online dispute resolution, can be very helpful, but it's very complex to put in place to automate it. So it's not just mediation being done with video cameras. If it's actually going to be technology and computer programs that helps people through their dispute. That's a great thing, and it's very impressive when it works. But I know from Canadian experience, set up in a province, hugely difficult, hugely complicated. Think of every possibility and program it in, but worth doing. There's some stuff here in the New York Convention that you can read about in the report. Next slide, please. So there are other areas of law reform besides the ones I'm talking about now, which are the main headings, but the action plan has several other headings in it, talking about taxation, valuation of digital trade, impact on taxation, hugely important in practice. The E-Commerce Association of the Kyrgyz Republic has talked about tax reform as well. So all of that needs to be considered in a harmonious way from start to finish with all the parties. But cross-border stuff becomes important. What is the declared value of goods coming in? It's even more complicated than that, but it's well worth doing, and we support it. Our report says, yes, good thing. Expanding e-signatures to apply to remote signing is important. A big challenge during COVID times when people couldn't meet in person. A lot of countries expanded remote signing possibilities very quickly during COVID, and some of those are not going back. So there are ways of doing that to think about. It's more technology than law. A couple of other mentioned. The single window is very important to international trade, to have one place that importers and exporters can refer to get their regulatory clearances. That should have a legislative framework. A lot of countries are developing those. The Kyrgyz Republic is not opposed to it. It's just we propose making sure that that's done, and you really know what's happening, and you know what the legal responsibilities of the parties are to each other in that process. Next slide, please. Couple of other, we mentioned, we recommend acceding to certain international conventions that I mentioned before, and paying attention to the international standards. If you're setting up a single window, the UN Center for Trade Facilitation has a lot of very applicable standards, and they should be to hand in any who's building that stuff. We just say that it's not, it's not magic, and it won't cause any surprises for people who read the report. Next slide, please. So we are taking feedback, including tonight, today, this morning, or in the world, from this workshop. We are planning on revising the report to take account of what we've heard. We've had some good input already, but we'll have more in the next hour. And anyone who writes us afterwards, we're going to create another report and send it to the government, and hope it'll be useful to them. So happy to hear your questions. I've read a couple here, and we'll have more. And I've got 12 seconds to turn it back to Gretchen.
Okay, thanks for that, John and Iskander. We have a couple of questions, but perhaps if it's okay, let's just go through the panel, the list with our list of panelists, and then we will go to the questions later on. So with that, let's start with the panel discussion. Our first panelist is from the Ministry of Economy and Commerce of the Kyrgyz Republic. For many months now, our TA team has been coordinating with their good office on this draft report and with the other outputs of the TA as well. Welcome, Mr. Nurlan Jusumaliyev.
Приветствуем господина Нурлана Джусумалиева.
Welcome, Mr. Nurlan Jusumaliyev, the head of the Trade Policy and Export Development Department of the Ministry of Economy and Commerce of the Kyrgyz Republic. Good morning, sir. What are your thoughts on the draft report?
Доброе утро. Что вы думаете относительно проекта отчета? Good afternoon, dear colleagues. First of all, let me on behalf of the Ministry of Economy, welcome all the participants and extend my respect to the team of ADB and appreciation of the organizers of this webinar and our experts. amid pandemic, the pandemic has shown that the electronic commerce gives a big benefit, is of big benefit to the economy. This is quite relevant in current conditions when the restrictions adopted with many countries affect the economy of almost all countries of the world. We hope that today's initiative will contribute to activate intensify the process aimed at implementation and development of e-commerce, and is a new and important domain of the economy. The experts are right that this sector is not that widespread in the Kyrgyz Republic. However, it is developing rapidly thanks to intensive economic base, relatively reliable internet, cheap internet, and strong PPP partnership. Kyrgyzstan has opportunity to become a center for e-commerce for the Central Asia countries, given the development of the logistics centers. Kyrgyzstan is aiming to present the country as a logistics center of the Central Asia. And we have achieved certain significant progress in it. The speakers have noted that Kyrgyzstan has adopted new law on e-commerce, new tax code, which provides some benefits for e-commerce. And the Ministry of Economy and Commerce is actively working towards optimization of legal framework and enabling beneficial conditions for e-commerce in the Kyrgyz Republic. I hope that this report will help us determine where we are in terms of improvement of legislation framework for e-commerce. Yes, we need to aim at improvements. I have heard the recommendations, and I have noted that we need to improve the law in terms of customs protection, cyber criminality, and other sectors related to e-commerce, and consider accession to international platforms. So this research will help us in future in decision making when improving the legislation framework. And in conclusion, I would like to thank the experts and wish all the participants good luck. Thank you.
Thank you, Mr. Nurlan Jusumaliev, for your inputs. Our next set of panelists will provide local inputs as well, as they are from the E-Commerce Association of Kyrgyzstan. The association was founded in 2018, and its goal and mission is aligned with the interests of online businesses in Kyrgyzstan. They seek to implement and establish international standards in the field of e-commerce, promote confidence in online shopping, provide expertise to facilitate the global expansion of online businesses, and create a platform for networking among its members. Welcome representatives of the Association of E-Commerce in Kyrgyz Republic. We have with us Aybek Korinkiv, its president, Bakay Bolut Ulu, its vice president, and Temirlan Sardalov, the assistant to the president. Good morning. Hi, happy to hear your thoughts on the draft report.
Good morning, dear colleagues. Доброе утро, уважаемые коллеги, дорогие друзья.
Good morning, colleagues and friends. Let me express my appreciation to the organizers of this webinar, ADB, colleagues from other organizations for arranging of such an important and relevant initiative for e-commerce subject. This is a significant assistance for us, and this is big contribution to development of the digital economy in Kyrgyzstan, I think. In short, I would like to tell about the activity of the association. The association was established in 2019, and it's 3 years. It's a quite young organization. However, for this short period, we have managed to achieve, make significant achievements. We developed a law on e-commerce. Second, a special tax regime was adopted, which is unique to the Eurasian space, Eurasian area. And we have further plans for improving the roadmap. And we have certain plans for facilitation and of the development processes. As for the report on the review on the e-commerce law, I would like to express my appreciation to the experts for this work. We were involved in the discussion. I would like to go through briefly on main aspects which require some improvement, but in general, I would like to note that the task group, the working group, which worked on the law, has managed to establish, to formalize main aspects and things needed for development. And we know that the comments on harmonization with the civil code, with other legislations, and there are some proposals for redistribution of responsibility level of the stakeholders, which is described in the law, and there is a proposal inventory of their sales processes and providing services, consumer protection. So these proposals are relevant, useful, and need to be introduced, implemented. Fortunately, our regulator, the Ministry of Economy and Commerce, and the government of the country acknowledges and understands the necessity of monitoring of this law and introduction of the changes relevant and needed. The most important is that we have a dialogue, we have analytical base framework, and we have expert support from development partners, and from ADB, which contributes greatly particularly in terms of development of digital area of the country, which is quite important. I would like to supplement briefly the report as follows. So let's start. This is comment of the association. We would like to see the law, e-commerce law. We see now that some discrepancies in standards as compared to WTO, and for further development and harmonization of terms, we would like to rely on more wide understanding of the e-commerce. Although the e-commerce law considers for goods and services, however, for purposes of the WTO, for further integration and facilitation of the process of introduction of international standards, we think it's needed. The law is needed to be renamed. The second relates to the level of requirement or responsibility, the high requirements to the trade platforms. So we think that at the development of this sector, at the development stage of this sector, the criminal sanction can be replaced with civil sanctions, with civil responsibility. And third, I would like to note that the law requires some detailing and harmonization of responsibilities between the parties of the chain of the service provision of e-commerce, meaning the rights of sellers, operators of trading platforms, mediators, and the rights of the end consumers need to be harmonized with each other. We understand that the processes are becoming complicated. We understand the law on consumer rights needs to be clarified more, and we understand that the responsibility cannot be imposed on the trade platform solely as a key organizer of the process of sales. We think that the responsibility should be balanced shared between the mediation clients, consumers, and sellers. And we propose to introduce, this is an association proposal. I've seen in the report some ideas on it. We propose to focus on self-regulation, following the examples of West countries and Eurasian countries. We are planning to establishing a single Eurasian Association of E-commerce. Under this association, we are planning to introduce the quality standard for the participants, and so we are against of introduction of mandatory register. We want that the participants, registration of participants of e-commerce is voluntary, not mandatory, and we need to focus on the quality signs, trust, and reliance, and consider the pre-court consideration. So we are willing to take over this responsibility and to take over the dispute resolution sphere. So, and we see that if the quality sign is introduced, then this will address the issue of collection of statistics data, since one of the big issues noted in the report was lack of the reliable information, timely information, statistical, economic information, and different discrepancies in the calculation methods, assessment niches between those of National Statistics Committee and ministries and so on. All of these hinders the monitoring, analysis of the strategy and shaping the strategy of a well-informed strategy. So I would like to note need for compliance, bringing in compliance of the law as in terms of the confidentiality protection. We expect that the law on regulation on cross-border sales will consider this issue, the protection of personal information. We need here a digital base. The Agency for Personal Data Information, the Personal Data Information Protection is working on this, and I would like to note that we have to carefully study the level of the responsibility of the liability and specify this in more detail and in more softer way, and to introduce a period of adaptation into the law, because the requirements to the operators and owners of personal data are quite high, including technical experts, and staff requirements are quite high. And at the same time, the liability for the responsibility for these requirements is critical, including full suspension of the termination of the activity of the enterprise. We see in this aspect some significant risk. Fortunately, the management of the agency understands this, but we would like to have a legal framework for the entrepreneurs to reasonably give their feedback or understand the implications of using these measures. And I would like to note the need for detailing of the law on consumer rights protection. We have noted the big part of the regulations for the regulation of the e-signatures, and we think that this law has some aspects to be harmonized as per the requirement to qualified signatures, e-signatures. And we would like to propose that the Association of E-Commerce hopes to have further initiatives like this to discuss more wider list of issues. We propose to establish a park of electronic commerce and facilitation of regional integration at the level of international organizations like Eurasian Union and Shanghai organization. Kyrgyzstan has quite beneficial geographical location and is willing to provide logistical, technical, economical opportunities, power, electric energy, and beneficial regime for neighboring countries and partners. I think this can be used widely, extensively for the integration purposes. This has a big potential, and I would like to know the big role of the training in skills in several sectors, in several categories: entrepreneurs, civil servants, businesses, and population. I think we have a lot of issues to discuss in future. In summary, the association proposed that using this draft report of ADB to establish a working group of the Ministry of Economy and Commerce, including all the required parties with their recommendations, and introduce the changes, amendments to the law to make it most efficient. And we propose that this working group mandates covers the changes, amendments and supplements to the tax code, since this situation is observed with the special tax regime, which was adopted in January this year and enacted from July this year. There are some restrictions and limitations which restrict the full implementation of some ideas like requirement to the businesses of this regime, to requirement for 100% cashless payment. This is not feasible, and this restricts heavily transition of the entrepreneurs from normal regime to the other beneficial regime of the tax code. So we have a number of proposals which we are willing to submit. Once again, I would like to extend my appreciation to all the participants. We value highly your works done, and we will use your outputs, and I hope in future we will have such the monitoring of performance of the laws on a regular basis and feedback, which would help manage the regulatory policy in Kyrgyzstan. Thank you, and I wish you a fruitful discussion.
Thank you, Mr. Aybek Kurinkiv, President of the Association of E-commerce in the Kyrgyz Republic. And your inputs are very important because your association, the businesses in Kyrgyzstan are the ones who really deal with who understands all the legal and regulatory barriers to e-commerce in the country. We can give a few more minutes in case Bakay Bolutulu and Temerlan Sardalov would like to speak, but if they think that the inputs from Aybek Kurinkiv are sufficient, we could proceed with our next panelists. We also note that the inputs from the association are substantive, and later perhaps John and Iskander can input on this later on. Bakay Bolutulu or Temerlan? No additional inputs?
No.
Okay, thank you. Now with that, let's proceed with our next panelists from the Central Asia Regional Economic Cooperation or CAREC Institute. The CAREC Institute is an intergovernmental organization dedicated to promoting the economic cooperation in Central Asia and is a knowledge support arm of the CAREC region. Speaking of CAREC, I failed to mention earlier that I note that there were capacity building needs that were mentioned by the association, and in connection with that, one of the outputs of our TA is the e-learning modules, and this is in partnership with CAREC Institute. So thank you so much, CAREC Institute. So our panelist holds a PhD degree in human resource development. He is a prolific researcher who has produced a consistent stream of research output that includes 40 publications in national and international journals, 9 conference proceedings, and 7 conference presentations. He has also completed numerous research projects and supervised PhD students. He was instrumental in launching a new international research journal called the South Asian Journal of Global Business Research, published by Emerald Publications. He has been actively involved in organizing a number of international workshops, seminars, conferences, fora. Welcome, Professor Kaysar Abbas, the Chief of Research Division of the CAREC Institute. Hello, Professor.
Thank you so much. So first to confirm, can you hear me?
Yes, all good.
Yeah, thank you so much. First of all, my great commendation to colleagues from ADB for such a great work on a very important topic, which is e-commerce. So I really appreciate and great for inviting me to provide my feedback or comments from the CAREC Institute. The report actually that is about e-commerce law in Kyrgyz Republic discussed the laws related to e-commerce, regulations, reforms, and action plans. Overall, it offers valued information to understand e-commerce development in Kyrgyz Republic. So here are some of my submission and suggestions which can improve, of course, the readability of this report. First, like section 3 of the report explain the detailed international framework. So here I would like to suggest that it would be great if we can discuss the Kyrgyzstan e-commerce framework collaborated with leading countries in e-commerce to define best practices. I think that a quantitative comparison may help in getting clear picture of where Kyrgyz Republic stands in terms of in comparison with best practice. This can be done, for example, by assigning some numeric codes, such as we can assign 0 if there is no law available in Kyrgyz Republic related to e-commerce of international best practices. 1 if there is law but without implementation of international best practices, and 3 can be assigned if there is a law with implementation of international best practices. So this quantification will not only help to understand current status of laws related to e-commerce in Kyrgyz Republic, but it will also facilitate comparing Kyrgyz Republic with any other countries in the same region, such as Central Asia. And it is suitable for, it provides suitable policy measures so for the policymaker for that particular country. So second suggestion that as we know that the regional integration subsection can add relevance of regional cooperation agreements on evolution of Kyrgyzstan e-commerce industry. So it would be great if we can add some information on that as well. A report further suggests that having sufficient legal protection and treaties, the e-commerce penetration is lower. So it is suggested to look into other formal and informal factors that impede e-commerce in the region and also in the Kyrgyz Republic. It can also be aligned with different current laws and regulation for an inclusive e-commerce framework. Fourth recommendations is like developing countries, as we know, that usually lack an implementation framework. So many developing countries have basic e-commerce and consumer protection regulations, but law enforcement is a matter of concern for all of these countries. So thus it is suggested that there is need to describe the implementation status and how and resolve of e-commerce regulation in Kyrgyz Republic. Number 5, as we know that accordingly to United Nations Commission on Trade and Development, consumer protection law is like drafted regulation in Kyrgyzstan. So there is need some more elaboration and explanation related to that particular law for the Kyrgyz Republic. And 6th, if it would be great if we can provide a comparative metrics table that can help the reader to compare and understand different attributes of e-commerce law, such as that strong, weak, not implemented, effective, etc. So it may help to understand an overall picture of the e-commerce legislative pillars in the Kyrgyz Republic. Next recommendation, it is also suggested if we can describe the transaction disputes, issues, hacked accounts, services as a case study and discuss their legal resolution, if any, of course, if any data is available related to this information. It may help to understand the actual position of people and businesses, trust and legal resolve. And finally, so maybe some, there is, it is suggested that that we need to apply some headings, subheadings, of course, that is formatting issues. So that would be taken care of. So again, my great thanks to ADB colleagues for inviting me to provide my recommendation and thoughts on this report. So I will submit formally in writing as well. Thank you so much. Over to you. I stop here.
Okay. Thank you, Professor Abbots, for your, I counted 7 recommendations on the report.
Спасибо,
And
доктор Кайсар, за ваши
we'll give
рекомендации, 7
John and
рекомендаций,
Iskander a
которые вы
chance
дали.
to respond on that later. Perhaps
Потом
if
Джон и
it's
Искандер
outside
ответят на них
the scope of the
позже.
study, then it could be included as part of the recommendations for
Может,
like a
мы можем
phase 2
их
or something
включить
of this
как рекомендации на фазе 2 этого проекта, да?
Okay, our next panelist
Следующий
is,
участник дискуссии у нас.
sorry, I'm hearing Russian translation in the English channel. Okay, thanks for that. Okay, our next panelist is Mr. Alexei Bondarenko from the International Trade Center, or ITC. Mr. Bondarenko is a trade facilitation consultant for the ITC and the vice chair of the UN Center for Trade Facilitation and Electronic Business. Mr. Bondarenko has a PhD in economics and solid practical experience in the implementation of various trade-related technical assistance projects in Central Asia. As part of the Ready for Trade Central Asia project, Mr. Bondarenko has conducted a paperless trade readiness assessment of the Kyrgyz Republic and has developed a set of recommendations for adherence of the Kyrgyz Republic to the Framework Agreement on Facilitation of Cross-Border Paperless Trade of the UN Economic and Social Commission for Asia and the Pacific, or UNESCAP. Welcome, Mr. Bondarenko. Happy to hear your thoughts on the draft report or any inputs, or share any inputs that you may have on the e-commerce developments in the Kyrgyz Republic.
Добрый день, уважаемые коллеги. Очень рад вас.
Good morning, dear colleagues. Glad to see you and discuss such a relevant issue. And I congratulate my colleagues from ADB with this great, wonderful report, which is quite detailed. I have reviewed it fully, and I found it quite useful for Kyrgyzstan. Lately, I have been living and working here in Kyrgyzstan. It was important for me to see your assessments. In general, the e-commerce subject is relevant to the ITC. ITC works in different countries and helps developing strategies for development of e-commerce, including one project in Kyrgyzstan, and where we analyzed the development status of e-commerce and submitted some proposals. And these proposals were included in the action plan, which will be adopted soon by the Cabinet of Ministers. I think the participants are familiar with this action plan. I would like to stop on the similar subject, which is cross-border paperless trade. Kyrgyzstan has big potential to become a regional hub for e-commerce, and in general, these issues of e-commerce are related to procedural issues. In our report, we have noted that yes, Kyrgyzstan has a good developed legislative framework which enables the e-commerce participants to interact electronically internally in the country, within the country. But if we look further, when you buy some goods from abroad, you need to share the documents with your partners, then at the end, you need to print out the documents and use the papers, since the state bodies and courts acknowledge the papers as when it comes to cross-border trade. Since the electronic signature becomes invalid in certain areas of the law, so therefore we need to switch to the paperless operations. And this situation is typical for many different countries. There there is the Economic Social Commission of UN for facilitation of the trade. Nowadays 8 countries have already joined this framework agreement, including China, Iran, Turkmenistan, and in the soonest future, the following countries will join: Kazakhstan, Uzbekistan, Russia. And therefore, the majority of trade partners of Kyrgyzstan will join this framework agreement. So therefore, this subject is quite relevant, and it was included in the roadmap of the Kyrgyzstan to facilitate the trade. We have used the methodology of UNESCAP to develop the liabilities of Kyrgyzstan in the Eurasian Economic Union. We have interviewed respective parties and drafted a report which was submitted to the board for trade facilitation. Conclusions that we have received under the researches are in line with much with those presented today. Kyrgyzstan there is no big activity in facilitation of paperless trade. There is no arrangement of mutual, of bilateral acknowledgement in process of the cross-border operations. For this, we need to use the paper documents. So to change this, we need to implement system-based political state policy and make popular the paperless operations among the state bodies. As for the legislation, we put the conclusion in our report that Kyrgyzstan has done much, like introduction of e-commerce law, and under the Eurasian Union, a lot of legislative acts were adopted to increase the trust to e-commerce. Since this regional aspect was not that detailed in the report, I would like to note several issues. First, Kyrgyzstan, as a member of the Eurasian Union, has certain liabilities and responsibilities. And the provisions of the international treaties, like Eurasian Union treaties, are higher and more mandatory than the national legislation. And so national legislation needs to be brought in line with this. The other issue is facilitation of trust in cross-border procedures. The countries, the parties to Eurasian Union have agreed that they will work on increasing the trust between the neighboring countries, between the parties of the Union. And this document developed under this initiative includes such terms like e-documents, e-signatures, and so on. And some of our proposals are similar to UNCITRAL provisions. And the most important restriction is cross-border trust facilitation. It aims to facilitate the trust between the state bodies only, between the members of Eurasian Union. We need that this provision should be improved to cover to provide legal legislation to B2B business form. So to facilitate the cross-border trust, many activities have been done. Certain documents were developed and which have The key of this document is a provision of trust between the parties. Kyrgyzstan is now introducing the trust services, which will lead to practical implementation of electronic share and electronic interaction in the Eurasian Union. However, this structure will serve for G2G information form, but we think that this structure can be used by other participants of e-operations, like participants of e-commerce. Eurasian Union has some agreed mechanism of acknowledgement of electronic documents. Yes, it's quite big and complicated. However, this document is in place and is able to ensure trust to the population and of the state bodies. So the acknowledgement So these tools for acknowledgement of the e-documents, electronic interactions can be used for operations at the high level, state level. So as for the flexible instruments of ensuring the trust, will be useful to facilitate the trust. The framework agreement of cross-border paperless trade allows harmonized the procedures for acknowledgement between the parties, and it's obvious that if Kyrgyzstan is a party to this framework agreement, then it can use these approaches and procedures with third parties. There are 16 recommendations in the report for the institutional and legislative framework, more than 50 recommendations related to technical aspect of paperless trade, and the output of consideration of this document was the decision to initiate the accession of Kyrgyzstan to the framework agreement. The proposed roadmap by us has 44 actions by 5 directions of paperless trade. So implementation of this action plan will reduce volume of paper used and will facilitate their predictability and develop the e-commerce in the Kyrgyz Republic. So this is my comment on the report. Thank you for your attention.
Thank you, Mr. Bondarenko. Thank you for sharing the things that ITC has been working on in Kyrgyzstan. And then we will see if there will be synergies with what we're doing in ADB. We will give the floor later on to John and Iskander to respond to your comments. At this point, Ms. Bauer was supposed to join us also. She is the legal advisor to the Commercial Law Development Program, or the lead of U.S. Central Asia Regional Working Group on Digital Trade. However, there were last-minute changes to her schedule, so we will just coordinate with her separately. So on now to our last, but definitely not the least panelist, because he came in, he's transmitting from Europe. We have with us Mr. Luca Castellani, who is very up early for this webinar. He is a legal officer in the Secretariat of the United Nations Commission on International Trade Law, or UNCITRAL. As Secretary of UNCITRAL Working Group 4 on Electronic Commerce, he oversaw the preparation of the UNCITRAL Model Law on Electronic Transferable Records, as well as of the UNCITRAL Model Law on the use and cross-border recognition of identity management and trust services. He has assisted several countries in the enactment of UNCITRAL texts on e-commerce. He is also active in the field of paperless trade facilitation and has contributed to drafting the framework agreement on facilitation of cross-border paperless trade in Asia and the Pacific. Welcome, Luca.
Thank you very much, Gretchen, for this kind introduction, and good morning to everyone, and of course, good evening to those who are on the other side of the world, like John, and who is now finishing his day, or maybe starting a new one by now. I thank you for inviting me and also for allowing me to make some comments on this quite interesting report. Of course, my perspective is focusing on the UNCITRAL perspective, and I do note and appreciate the fact that the report makes several recommendations to expand actually and to adopt UNCITRAL texts. Of course, I agree with that with that recommendation, but I think in order to appreciate why that I agree with that recommendation, we needed to put things in perspective and also maybe take a step back and see a more general policy approach to the issue. Central Asia has been a little bit of an outlier when we look at the law and the regulation of electronic transactions. When this process started on a major scale, and that's already 30 years ago, the focus was on the benefits of exchanging information at a very limited cost, in no time, all over the world. And so, if you wish, in a way, the actual interest was for digitizing documents, and these documents were digitized one by one, and specific requirements were set up for each document, and the stakeholders interested in each document would concur to defining the requirements for the document. In Central Asia, we have seen more of that because there was a legacy of having the economy develop according to a central plan, and a legacy of a high level of regulation and control of the government over the economy, which does create a fundamental policy question with respect to the role of the private sector. When we go back to electronic transactions, we have seen in the last 30 years a shift from that case-by-case approach to a comprehensive approach. Nowadays, the importance of the use of electronic means is not limited to convenience in transferring information. The focus is actually on the ability to compile, analyze, and reuse data. And the approach that focuses on specific standards for specific documents creates additional obstacles in that respect, because these may lead to the creation of what we call data silos. Data silos is a real issue because we put the information in a bucket and we are unable to take it out of there. Data, of course, there has been a lot of discussion about data. At a certain point, everyone was saying data is the new oil, which was also not accurate because data is very different from oil in many ways. But data is also a commodity, and data, of course, nowadays accompanies, especially commercial transactions, but not only all of them. And it's critical to realize that for the flow of goods and services, there is always on the side a data flow that needs to be equally taken care of. Where does this take as now. I have seen the existing legislation of Kyrgyzstan, and I have to say, especially the new law on e-commerce. And I have to say that, in my opinion, it represents already a significant step forward compared to the average of the laws in the region and compared to the tradition that I was referring before, which focuses on the regulatory aspects of the use of electronic transactions. In particular, of course, the number one problem in the region is technology-specific requirements. So the need to use certain technologies and certain technical standards in order to have legal effect and recognition of the electronic document. That's the real issue, the elephant in the room, if you wish. Because each national standard, by definition, is not compatible with our national standards. We know that there has been a lot of work in creating cross-border standards, especially in the Eurasian space. But again, a lot of work over many years has given some results, but still we are only at a regional or sub-regional integration. We are not at the global integration. And I have to say that we have worked recently with, as Gretchen just mentioned, we have just finished a model law on this issue, but having a different approach. And what's the approach? We all appreciate that there is a paramount need for trusted data. So we need to have trust in the quality of data. We have to have assurance in the quality of data, more so every day. Data which, by the way, are mostly in the commercial field, are mostly not generated by people, are mostly not generated by companies. Data are mostly generated by objects. So we are talking about trusted data, for instance, with respect to the Internet of Things, for instance, with respect to automated supply chain management. Incredibly important, Alexei was discussing paperless trade facilitation. That's incredibly important in that field. But the approach of UNCITRAL and the prevailing approach in the world is, when it comes to transactions among private individuals or commercial operators, so when we're talking to B2B and B2C, the parties must be free to decide the technology and security they prefer. And we see that in the Kyrgyz law, but I don't know how much this is coherent with the other legislation, in particular with the use of electronic signatures and other trust services. So this is the number one priority, to make sure that this is taking place, because it opens the door to what I said before, data flows that actually avoid the creation of data silos. And in that respect, it's really important also to complete what already exists. And there are a couple of provisions in the law that are clearly inspired by UNCITRAL texts, but it's just a few paragraphs here where I think it's Article 12 and 14. And there's much more there that could be given to provide guidance to parties on how to exchange electronic communications and electronic transactions without, of course, becoming too detailed in regulation. A different approach could be needed and is often needed when it comes to transactions with government, because, of course, government has different and higher standards. But nevertheless, that approach has still to be mindful of these two paramount goals, which are, on the one hand, technology neutrality in the legal field, on the other hand, technical interoperability in the technical field, because these are the two guiding principles that allow us to effectively enable data exchange. I appreciate one could reply, this is all good and well at the policy level, it's aspirational, this is not, however, in line with the local needs, this is not in line with the local regulations, and this does not reflect the current reality. Well, I do agree with this may not reflect the current reality. I do agree with there is a need to have a discussion on certain policy choices. And I'm not necessarily speaking about Kyrgyzstan here. I'm not familiar with the details of the country, but I'm speaking more generally about Central Asia. But I also do appreciate that Central Asia has its own special challenges, especially in terms of the landlocked nature, costs, for instance, of the import-export of physical goods, connectivity, so on and so forth. And therefore, I do believe that now the time may have come to reassess certain fundamental decisions and to open up at least when it comes to B2B and B2C exchanges. And I very much welcome the fact that the recent Kyrgyz law goes already in that direction. And I believe that the report makes important suggestions in the same direction. From the operational point of view, of course, the first recommendation of the report that I very much endorse is the suggestion to adopt enabling international agreements, that is, on the one hand, the United Nations Convention on the Use of Electronic Communications in International Contracts. On the other hand, and here I fully agree with Alexei, the framework agreement on cross-border paperless trade facilitation in Asia and the Pacific, which provides the framework, if you wish, the sandbox to experiment trade facilitation measures, both on the legal and on the technical. But I would also like to mention as a final comment the UNCITRAL model law on electronic transfer records, because it is now seen as a real revolution in the field. It has been twice endorsed by the G7, for instance, and it's now, thanks also to the work with ADB, with actually the supply chain and trade financing group. We are promoting it very actively in Asia, and this could be particularly useful, in particular, for paperless trade facilitation, because it allows the digitization of certain transport documents. And it's also in line, and this is very specific, but I think it's also very important, with a project that we are now having at UNCITRAL on negotiable railway bills that is supposed to enable trade financing along the, in particular, along the railways that carry goods from Europe to Asia, and therefore extremely important for Central Asia. So this is something that actually will be starting at the working group level in November in Vienna, and we will be busy with it in the next few years. And so I seize this opportunity also to draw the attention of our colleagues of Central Asia on this project, hoping that they can join us. So these are my comments. Sorry, I might have gone a little bit into the time for Q&A. I hope that is useful when I'm here. Despite the early hour, I'm here for any question you may have. Thank you.
Okay, thank you so much, Luca. I'm supposed to pass on the floor now to John and Iskander, but maybe we have some time to just go through the questions here in the chat because we don't want to lose our audience attention. Perhaps Zore Abdirahman, are you still here with us? If you would like, you could just go ahead and jump in and read your question to our esteemed panelists. Perhaps, John, Mr. Zaure Abdirahman, go ahead if you're here. Or if not, I can just read if you're shy. Okay. So he's saying Article 1 of the law indicates that it shall apply to B2C. What about B2B? Whether certain terms and provisions of that law should apply to B2B as well. This is to business instead of business to consumer. It shall apply to business to consumer. What about B2B, business to business? John, do we have a quick feedback on this?
Well, my feedback in looking at the statute, which I have in front of me here, is that I don't think it's limited in that way. I don't think it applies only to B2C. I know it starts out by saying this law regulates public relations between individuals and legal entities, but I don't think it does not apply to relations between legal entities and other legal entities, that is to say, businesses. And if you look at the definition of electronic commerce, it is not limited to individuals. You look at the definition of electronic transaction, it's not limited. And if you look at the obligations of parties to each other, it's not limited. So I don't think it is so limited. In any event, the provisions here are a set of obligations, but the main obligation in a transaction is, as I said in my report, found in the Civil Code, which is certainly governs B2B transactions. What the law about electronic commerce does is it says you may do this electronically, but it doesn't have to do very much to say that, in the sense that that's probably true in any event. But I would, if it's generally understood within the Kyrgyz Republic that this is a law that is only B2C, then I'm surprised and I don't see it that way. But of course, I'm not reading it in the original, and maybe I have things to learn. I mean, in my view, there's no reason that most of the provisions of this law should not apply in B2B. So I'd be interested in discussing that further, but I would be surprised if it's just B2C.
Thanks, John. And then our next set of questions is from our Law and Policy Reform Supervisor, Ms. Christina Pak. Christina, would you like to share your questions, or I can just read them if you're shy? Okay, perhaps I read them. She's asking who would be important to include in the capacity building to increase uptake of e-commerce in Kyrgyzstan? And another question is there on online dispute resolution, is there a developed framework for this? Is CAREC involved in this? For example, APEC and ASEAN have regional initiatives in online dispute resolution, given it's identified as a key challenge for SMEs. John, or perhaps the government, Mr. Nurlan, I don't know if you want to input on these questions. Or Iskander, who may have some background on the local background, on the local front.
Yeah, if I could start on that, I'd just say I really don't know what the resources are available. I think it's a good question. If you're going to need capacity building, and there was some suggestion even from the association on e-commerce that capacity building was going to be necessary. I don't know where you go. You go to the ADB and say, hey, folks, give us more help, set up another TA. It may be that the CAREC Institute has resources as well in coordinating all the member states. Some of the member states are more developed than others and more developed than the Kyrgyz Republic in some of these areas. But the ITC itself, the organization that Mr. Bondarenko represents here, has a lot of resources, has a lot of knowledge about this area. But where you go specifically for specific questions, I can't help you on that so much. Maybe you go to Luca Castellani, who seems to know everything and know everybody, and he'll set something up for you. I know that UNCITRAL does, in fact, provide technical assistance in implementing the UNCITRAL instruments on electronic commerce. So that's not a frivolous suggestion to say that's one possible source. But I'd be happy to hear what Iskander says as someone who lives and works in the Kyrgyz Republic, and of course, Mr. Nurlan as the person in the ministry responsible.
Yeah, Nurlan or Iskander, and then there's a follow-up. Which groups would be the participants? And as mentioned earlier, we have the output 2 of this technical assistance, which is the e-learning modules available at the CAREC e-learning website. I will share more on that later on, but I'll pass on the floor to you to elaborate on the question. Iskander or Mr. Nurlan?
I think basically it's the question for the ministry. They know a lot of things about the policy and a lot of things who should involve in the policy. I think basically it's the question for the ministries. If Mr. Nolan is available, I think he can answer to these questions.
Mr. Nurlan, do you have any inputs on this question? Okay, he's probably not here with us. But anyone else from the association, perhaps you would like to input on this? Who would need capacity building? And then I think I'm getting the question of Christina, because it's a needs assessment and it would help us design further TA design, with input on the TA design that we would have in the future. So it's important for us to find out. Mr. Nurlan or the association, if you would like to feedback. Okay, we'll just find out offline. Now, because there were a lot of things mentioned by the panelists earlier, I pass on the floor now to John and Iskander. That's a lot so perhaps we could give it a few more minutes for your inputs.
Well, I guess the main, I'll mention briefly the ODR question, the online dispute resolution question that was asked about what else is being done. APAC is doing things, the CN is doing things. Is CAREC doing anything? Dr. Abbas could certainly speak to that better than I could. As I said briefly in my remarks, I understand that the Chamber of Commerce for the Kyrgyz Republic has got a program of ODR that it's developing. And frankly, I learned that from a report that Mr. Bondarenko did for the ITC. So Mr. Bondarenko could probably speak to that more than I can as to what's being done. But there is some beginnings of some initiative on ODR. But I mean, ODR can be either taking regular dispute resolution online. So you do a mediation, but you do it by video presentation. So the parties are meeting by video rather than in person. That could be ODR. That's not the most important kind. That's easy. If you have the video connections, it's easy. So it doesn't really need a lot of legal explanation. The interesting part of ODR is setting up interactive computer programs so that, say, if there's a merchant and a consumer disputing, each gets to tell his story to the computer, which then feeds back certain questions or says, if you have this problem, then here are 2 options. If you take this option, then this is the further option. If you take this decision, then here's the possibility of settlement. It's very impressive when it works, but as I said, it takes a lot of thought to have the decision tree, decision chain options functional without leaving things out. and in a way that works for both sides, that both sides can track the thing through and decide when they're agreeing and when they're not agreeing. If they're not agreeing, what else happens? Most of those systems involve eventually a live human being stepping in and saying, all right, I've seen all your answers now. There is still a narrow point of disagreement that needs a human, either mediator or a human judge to do it. But it's a fascinating area. UNCITRAL had a working group on electronic commerce, did a project on online dispute resolution 10 years ago or more, which did not in fact succeed because it was not able to resolve the issue of how you got both parties to participate in the online dispute resolution system. You know, if everyone agreed to do it, it was fine. But if people did not agree to do it, could you force them in? And if so, how? Luca could speak more to what happened to that. Anyway, a good question. I could go on for a long time, but I won't. The other main points of substance we heard tonight were from the E-Commerce Association and to some extent from Mr. Bondarenko. I've read a presentation or submission from the E-Commerce Association. I must say I don't understand some of the points made on it. I think it's not something that I can discuss here very comfortably. I mean, they want things that it seems to me the law already gives them. They want some things about the tax code that I think are beyond the scope of the current report. They want an e-commerce park, which I think the government also wants. I think it's in the action plan. But again, it's beyond the scope of the report, whether it's for another TA by somebody else later. I can't say anyway. So I'm not very helpful on responding to them. I have sent them some comments and questions, so it may be that we can resolve that offline in a way that would affect our final report when we come to give it. With Mr. Bondarenko, I have read his report on the assessment of readiness, legal and technical readiness for cross-border paperless trade for the Kyrgyz Republic. I think it's a very good report. It has a lot of recommendations, and I think we would support them. So, and he supports many of our recommendations. So I think we're fairly friendly on this one. It may be that in preparing our final report as well, we can develop them. If he has specific issues that he wants to raise, he can try again. It may be that, you know, just the translation was too much for me at, you know, half an hour after midnight when I'm listening to this for me to pick up his points in a way I can respond to. If Iskander is a better way of getting to it because he didn't need the interpretation, that's I'm happy to let him step in.
Any other inputs? Yes. Go ahead, Iskander.
Я бы хотел сказать, что, как уже отметили члены...
I would like to note, as the association has mentioned, we need to continue our works towards development of the legislation, consultations, establishing working groups. I think this will be a good, successful start and good assistance, not only for the entrepreneurs, but in general for the population which is interested in implementing and accepting and going to the digital space. As John said, we need to additional offline consultations. We will try to have them include the ITC staff and Alexey Bondarenko and the members of this conference. Thank you.
Thank you, Iskander. So we are mindful of the time. We only have 2 minutes on the clock. So is there anyone else who'd like to say their final words before we end this webinar? Of course, all of the inputs that we've gathered here today We will include them in the revisions, or we consider them in the revision of the draft report. So do send them in if you have any additional inputs via email. We will take them into consideration. Is there anything else anyone else wants to say before we leave? Okay, I mentioned earlier about the output 2, which is the e-learning on e-commerce in Kyrgyz Republic. And I am very happy to inform everyone that yesterday this has been made available at the CAREC's e-learning website, e-learning.carecinstitute.org/e-commerce. We will email everyone who thinks it might be interesting for them to take this course. If there's anyone else, we will close. Anything else? Okay, well, thank you everyone, to the presenters, John, Gregory, and Iskander Artigbayev, to the panelists, Mr. Nurlan Jusumaliev, Aybek Kurinkiv, Bakay Bolutulu, Temerlan Sardalov, Dr. Kaisar Abbas, Alexei Bondarenko, Luca Castellani, to the TA team, Borjan, Ria, Noray, and to the Law and Policy Reform team of ADB's Office of the General Counsel, Angelo and Gladys, and to our interpreters, Gulia and Asel, and to all of our participants. Thank you so much for your questions and your inputs. Thank you for your time and participation. In relation to this TA, we're also happy to share that we have ongoing initiatives in Mongolia and Cambodia, and we'll invite you once we have the details. So hope to see you there as well. So thank you, everyone. We'll see you again on our next webinar. Thank you for your time and for your participation. Thank you to our panel.